Mr. Smith said, "I will buy your shares out for £200,000, which was a pretty good offer. Even if Mr. Song had succeeded in proving his case, he would have failed. He wouldn't have got judgment in his favour because he turned down that offer." Now that is a classic O'Neill and Phillips offer. Let's talk about the case of Song versus Smith. It's all about the power of making an early offer to settle. Now, in shareholder disputes, the prime case about making an offer to settle is O'Neill versus Phillips. If you ever speak to a solicitor about a shareholder dispute, even if you get a letter from a solicitor about a shareholder dispute, pretty soon they're going to start quoting O'Neill versus Phillips. And why are they going to do that? They're going to do that because in that case, it says that if a fair, reasonable offer is made early on in a dispute, then you cannot claim to be the victim of unfair, prejudicial conduct. Song and Smith, what happened in that case? Well, Mr. Song was an investor in a company. Mr. Smith was a builder. It was a company built to develop housing association properties in the Cardiff area. Song provided the money, Smith provided the work and the know-how. In its simplest terms, at one point in the proceedings, when the business was up and running, even though his money was still required, Mr. Song refused to invest any more money in the business. Mr. Smith carried on. He was the guy that did the work, ran the projects anyway, and so in the circumstances, he finished 2 of the projects and took a 3rd project as far as he possibly could. Mr. Song issued a claim against Mr. Smith based on breaches of directors' duties, saying that he had basically enriched himself to the detriment of the company. Mr. Smith countersued, saying that Mr. Song's actions had also been to the detriment of the company. The court didn't like any of those claims and so dismissed both Mr. Song's original claims and Mr. Smith's counterclaims. What the court did say that was very interesting, though, was in relation to an offer that Smith had made in 2022. The crucial meeting between the pair was on the 4th of July 2022, when basically they decided to go their separate ways. In a letter from his solicitors, 10th of August 2022, Mr. Smith said, "I will buy your shares out for £200,000, which was a pretty good offer because at the time, the 2 associated companies that were part of the litigation were worth respectively £83,000 and absolutely nothing. So that was a decent offer. Smith also said, look, if you don't like that money in the same offer, we can have a valuation and we can go from there. Song turned down that offer. Now, not only was that a bad idea from the point of Song, the court had something very interesting to say. It said, even if Mr. Song had succeeded in proving his case, he would have failed. He wouldn't have got judgment in his favour because he turned down that offer. Now that is a classic O'Neill and Phillips offer that was made and rejected and meant that proceedings wouldn't have succeeded. O'Neill and Phillips offer must have certain criteria, certain characteristics, and these are, it must be a reasonable offer. That is, it's an offer to buy shares at a fair value. And fair value means taking all the circumstances into account, usually without a minority discount, which is something that usually comes into play, or something that often comes into play when valuing shareholders. The offer must also be seen as a viable alternative to court proceedings. Now that means that the offer should encompass all of the possible remedies that the other side would get from court proceedings. So, as well as just buying the shares, if for example you haven't paid dividends for 10 years, you've also got to put in compensation for those lack of dividends into the offer. It must also include an offer of a valuation. Even if your offer is generous, as Mr. Song's was in the Song versus Smith case, the other side must be allowed to have a valuation if they want it. The offer must be based on a valuation from an independent expert, which is what the court would order in any case. And finally, an O'Neill and Phillips offer should be in an open letter, should be open correspondence. The alternative to that is without prejudice correspondence, which means that the court can't see it unless both parties agree. So an O'Neill and Phillips offer, excellent way of avoiding litigation, but it must be reasonable. must be seen as an alternative to court action, so include all of the remedies available, an offer to settle all of the remedies available to the other side, must include an offer for evaluation by an independent expert, and it must be open. Song versus Smith, interesting case where both parties sued each other and neither won, but the court had a lot to say about O'Neill and Phillips' offers. I hope that was helpful. If you are in a shareholder dispute, if you'd like to settle it by making an offer without the need for court proceedings, then please come and speak to us. Speaking to us is easy. Go onto the website, press the book a meeting button. That takes you straight through to my calendar. That will give you a 30-minute meeting, which is entirely free of obligation, free of charge. It would be great to speak to you. Alternatively, give us a call, drop us a line on an email, or leave a question in the comments below. Or if you've got any comments on the video, we'd also love to hear from you. Thanks very much.